guys in random groups, if you came into class late, please come grab your name tag. And I'll get you into a group further when it's time. We're going to be doing an activity today. I'm going to jump over to our torts information. While I'm jumping into that, what does torts mean? Wrong. Who said that? Lillian, loud and proud, what does tort mean? Wrong. Tort is a fancy way to say someone did something wrong. Do people do things wrong? All the time, especially in business. So we're going to talk about 3 different types of torts. This is one of my favorite topics. I love the topics that deal with people. Okay, so torts deals with a lot of issues with people. We're going to talk about the different types of torts. There's 3 different kind of categories we're going to address. So we're going to start today. Probably we'll only get to discuss intentional torts. Then you'll see on Monday we'll talk about what's called negligence. We briefly learned about that before. And then we'll also talk about strict liability. So those are the 3 types of torts you want to be familiar with. Get the chalkboard up here. Come on. Work. The computer's slower than I am, I know. So we're going to talk about tort law today. We'll talk very briefly about how that relates to the other types of laws we've been talking about, criminal law, and we'll talk about those 3 categories again. One of the big things we're going to talk about today are damages. What are damages?
Something gets broken.
Something gets broken. So in court, something got broken, and I'm suing you, and I'm hoping to get damages. I'm hoping to get what?
You're going to get paid.
Thanks, Sean. Get paid. I'm hoping to get money. We're going to talk about the money part of this today. Then we'll get here where we'll talk about intentional torts. Again, we'll cover negligence, some defenses to it, and strict liability on Monday. Why is this not working today? Come on. That stinks. I love this thing. Okay, I'll survive. Discuss tort. So we're going to talk today. Tort is a violation of a duty, something you're obligated to do under civil law. So who's suing you when it's a tort if it's civil law? Someone did something wrong?
Your neighbor.
Yeah, it could be your neighbor, it could be a business, it's an individual. This is not the government. We're not talking about crime right now. Again, tort means just someone did something wrong. So when we compare these under criminal law, remember it's behavior that the society says is wrong. The government's prosecuting. There's a very high burden of proof beyond a reasonable doubt. Man, this thing is not working. And then contract law, we're going to talk about in Unit 3. We'll cover this for a few weeks towards the end of the semester. You know, this is based on, hey, we made an agreement, you broke our agreement. Okay? Under torts, we're focusing more on you had an obligation, there was a wrong. So it's very similar in that way, that it's civil also. But here we're focusing more, it doesn't need to be an agreement, it's simply that you had some kind of obligation, and you're hoping to get compensation, or what we call restitution. And we want to try to bring you whole again. Make things fair. So here are the torts. We have intentional torts. What was the other type of tort?
Negligence.
And there's one more.
Strict liability.
Strict liability. For some reason, because we covered that one last, my students totally forget about it for the exam day. So remember, strict liability is a big one, and we will talk about it on Monday. That guy is just rolling in the dough. We need to talk about the money stuff here because it's important. One of the things students don't always know about is this. It's called the single recovery principle. This basically requires that when you go to court, you say someone did something wrong, you collect all the money you want to collect that one time in court. So what I can't do is say, hey, I had an issue. We're going to learn about defamation today. Sophia defamed me. She posted, Professor Weiser's the worst professor in the world. She drinks. She's drunk in class. She's, says really inappropriate things. And she posted on the web. We'll learn today that could be defamation. And so I say, oh, Sophia did this to me, and I go after her, and I get $100,000. I win, and she has to pay me $100,000. That stinks, right, Sophia? Then 3 years later, I see Sophia again, and I see she's really successful because she's going to go to a great college after this, and she's doing really well for herself. She's making millions of dollars. And I'm like, all I got was $100,000, and I go after her for another $500,000. Does that seem fair to Sophia, even if she wronged me?
No.
So this says, hey, you have to settle everything, the whole matter completely. Where this comes into play a lot is when you have a medical issue. Let's say you get into a car accident. On the beltway around here, that happens quite a lot. And so you go in and you want to say, hey, this person, did $10,000 in pain and suffering. I have all these medical bills. And so you sue them, you win, and then your back's still hurting you 2 years later. You want to make sure that you do not go through the case and try to collect all the money, and then you end up in a space where you don't have what you need. So they'll tell you, like, if your back's hurting, you got in a car accident, to wait. You can obviously sue the person immediately and get some money right away. Normally they'll say wait, so it's easy to prove. The doctor, I go in every 3 months and get a doctor to say, yep, her back's still hurting, she still needs physical care. That way you can show there's still been injury going forward. You can also try to make an argument, like, hey, my back's bad and it's going to be bad for 2 years. It's just not as credible as really showing for 2 years it has been bad. And there's no harm in waiting those 2 years. Within statute of limitations, some states you can only wait so long before you bring a case. So in general, you really want to make sure you get paid out completely. Here's all my future pain I want you to account for as well. I can't go back later and try to get all Sophia's money. In most cases, the jury can say, here's what we think is what you should pay. It can be whatever they think is important to give you. We'll talk about, there are limits in some states. We talked about that before. For example, in Virginia, there was a $15,000 cap for people who had been hurt on that plane crash. They said depending on the state, there can be limits to how much is given. But some, it's as much as they think is fair. I get the question all the time, like, how do I decide how much money? As a rule of thumb, like in personal injury law, a lot of lawyers will take all the expenses you had and multiply by 3. So real expenses. If you get in a car accident, a real expense is like your car has $5,000 in damages. You have $10,000 in medical bills. And then you say, you know what, I missed, $5,000 worth of pay from my job because I couldn't work. They'll take that $20,000, multiply it by 3, and they'll ask for $60,000. They'll say that other $40,000 is pain and suffering. That's kind of the math they do. I won't tell you that makes any sense or logic, and again, it could be more if you hurt your hand and you're a musician, for example. So it does vary. You can ask for whatever you want, you just might not get it. So there's different types of damages. Sorry, I forgot this thing's not working. And that's not working there. There's compensatory damages. You definitely want to write this down. It's something you would see on an exam. It's something I want you to understand the difference between the two. Compensatory, and what's the other one called? Punitive. Thank you, Aklima. Compensatory and punitive. So you'll see here under compensatory damages, a good way to think of these is anything you need to pay out to a victim who's been wronged to make them whole again. So that's pretty easy to see. It's things like your medical expenses. Now this is interesting because we're generally required to have insurance, right? So if your insurance covers your bills, that's great, but you'll get paid out for the full medical expense anyway. Okay, so you actually get more if you have insurance. The insurance covers it. You can get paid out for the full medical bill anyway because you opted to have that insurance. Here you'll see any lost wages. I can't say, oh, I make $1 million a day and get $1 million a day in lost wages. I can show, here's a paycheck. I usually make $20 an hour, and you can get paid for any lost wages if you're out of work for a few days due to some type of wrong. Things like pain and suffering. This is one students get confused about. Pain and suffering is a compensatory damage. If you're out of work and you're in pain because someone crashed into you on the beltway for a whole week, that stinks, right? Like, that's not fair. You're in pain, you're uncomfortable. So we call pain and suffering a damage, a type of expense that you have. And again, to make you whole, we want to pay for that pain and suffering. Now, does that fix, like if your hand got broken off, does that fix your hand?
No.
No, but money, hopefully makes it a little better. It's a way to try to compensate. And so that's the idea with compensatory damages. We want to try to make you whole again. Punitive damages focus more on what? What do punitive damages focus on? Punishing people. So we've repaid you for all this stuff that had you not had this wrong happen to you, you would not have had those expenses. You would not have had that pain and suffering. We repay you for all that stuff under compensatory damages. Punitive damages, these can be huge. This is saying we want to prevent this kind of thing from happening again. So we're going to charge you, $1 million and make an example out of you so that other people see that the outcome of this case and see, if I drive 30 miles per hour over the speed limit, I might not just be responsible for someone's damage to their vehicle, I could be facing $1 million in extra damages. And that's a lot. Now keep in mind, I win in court against Joe Schmo, and I win $3 million total. Both compensatory and punitive damages, I get $3 million. Joe Schmo is bankrupt, has nothing to his name. How much money do I walk away with? $0. So do keep that in mind. There's some limits to this and what's actually available, even if you do win. So sometimes they make an example out of, especially businesses, and you'll see huge punitive damages to kind of punish them, really hit them in their pockets. Often it's closer to what the compensatory damages are that are awarded. Go ahead, Michael.
So if you won a case like that where the other party was bankrupt, how does that work going forward? Do you get any of their paychecks going forward, any future money or no?
There's things you could do. You could dock their wages. They could have a court order sending them to jail for not paying you. But the fact is then they're in jail, you're still not getting your money.
Right.
So
I'm just saying, like, say he went out and got a job, do you get any of his future money?
you can try to get the court to give you to dock his pay. You'd have to have the court order that.
Okay.
Where that comes into play a lot is with child support.
Right.
So that happens a lot where someone will be ordered to pay child support, they're not paying. You can bring them to court. I worked for a family law firm. We bring them to court and you can dock their wages and get an order put through that automatically takes like $300 a week from their wages. That's hard to do. If a judge agrees to do it, you have that court order, it happens, there's still nothing to stop them from quitting their job or getting fired. And then on top of that, let's say, okay, they're not paying, they quit their job. Well, they're not paying what they're supposed to be. They're supposed to pay $300 a month. Well, we get a court order throwing them in jail because they're in violation of what they're supposed to be paying. Now they can't pay their child support anyway. So sometimes it's not beneficial to do those kinds of things. It just depends on the situation. Sean, did you want to say something?
Yeah, kind of what you asked. If the court would say that you won the case for $3 million and the person was broke, why would the court even say you won $3 million if they know the person can't pay it to you?
Great question. Sean's asking, like, why? If they know this person's broke, why would they do that?
You'll never get the money.
Usually you don't know a lot about the person's finances. That's not part of the evidence in the case that the jury's hearing unless for some reason it's relevant. So they wouldn't know necessarily that person's broke, right? Usually there's insurance involved when we talk about these wrongs, so we can at least collect from the insurance. And then on top of that, remember that important word precedent. It sets a precedent. Even if this one person can't pay, if a similar issue like this arose, the others might be able to. Even businesses that make lots of money, keep in mind if they get hit with a $3 million bill in legal fees, that business can go under. If that business is bankrupt, then they don't have to pay you. So a lot of these companies you see, they're limited liability companies or limited liability partnerships, they've limited their liability. It's like a separate entity. They can go completely bankrupt, and there's not a lot you can do about it. It's a tough situation. Another weird thing when we talk about the money part of cases is this thing called the eggshell skull principle. Who remembers that nursery rhyme, Humpty Dumpty? So what happens? Humpty Dumpty sat on a wall.
He had a great fall.
Humpty Dumpty has a great fall. I
No,
fall
of
off the
course.
desk. Am I in pain? Am I injured?
No.
Maybe. I have heels on. Maybe I sprained my ankle. Will I survive?
Yeah.
Fine. Humpty Dumpty, an egg falls off of this. Will it be okay?
No.
No, it's going to shatter into a million pieces. That's what the eggshell skull principle is about. You take your victim as you find them. If you do a wrong to somebody, even if it's like ridiculous, the amount of damages that happen, the consequences of that, they were an eggshell and they shattered and they died, all because they fell off this small little thing, when a normal person maybe would have just sprained their ankle. You take your victim as you found them. You still did the wrong. So if someone has very fragile bones, you get into a car accident, they have fragile bones, a normal person would have been okay, it was a small accident, but you happen to hit somebody who has very, 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 very bad bones and they break 50 bones because of it. A normal person would have broken maybe one. You still broke 50 bones, so you'll still be responsible. So you take your victim as you find them. That's the idea behind this. Scary, right? Careful who you crash into. Also try to avoid crashing into those nicer cars, like the So every intentional tort requires intent. Here's another big thing to keep away. Students get very confused because it's called an intentional tort. There actually doesn't have to be an intent to do anything wrong. You don't have to be a mean person. Okay, intent actually is simply intending the act itself. Doesn't mean you intended to do anything wrong, you just intended the act and it had a bad consequence. So we're going to talk about a number of torts today, but before we do, I want to talk about that idea of intent. Remember, if you see a scenario like this, do you think it's likely it'll show up on the exam? Yeah, so here's something you want to star in your notes and highlight, right? We talk about it. Do I have any soccer fans in here? I got Christian and Michael. So Christian and Michael, we're playing soccer. I got my heels on, right? And I am not athletic. I will not claim to be. So we're playing soccer for fun outside. It's a beautiful day. And, Michael passes it to Christian successfully. Christian passes it to me, successful. I, let's fall over and somehow get it. And I go to kick it back to Michael, right? And so I go like this, and I kick the soccer ball, nice. And it ends up hitting Michael in the head and injuring him significantly. He has a concussion. I don't know how I kicked it so hard. Somehow I did. I'm so sorry, Michael, right? Did I intend to hurt Michael?
No.
You guys are being too nice. We don't know, right? Probably not, right? I didn't intend to hurt this person. What did I intend to do? Kick the soccer ball. Did Michael get hurt?
Yes.
That's the idea behind an intentional tort. If I hurt somebody as a result of my actions, even if I don't intend to hurt somebody, I am intentional about the act I am doing, and I'm responsible for the consequences. So poor Michael, he got hurt. Is it fair for Michael to be responsible? No, so I'm going to be responsible. Now I'm going to probably get the question I'm hoping to get from Curtis. Go ahead.
Isn't it an assumed risk?
Good question, Curtis. We're going to talk next class about a defense to that called an assumption of the risk. We're playing soccer. Is it possible you get hurt with a soccer ball when playing soccer?
Yeah.
So I could defend myself and say, Michael assumed the risk by engaging in soccer with me. He knew that he could potentially get hurt. Soccer is a dangerous sport. We'll talk more about that next class. Go ahead, Michael.
So, kind of going off that, would that tie into if you're actually playing soccer like on a team and on the athletic field and say you got hurt during the game, which is part of the sport, could you pull that up in court?
Absolutely. You could definitely pull up in court. Is it going to be successful? Probably not,
Yeah.
because that defense we're talking about,
Mm-hmm.
assumption of the risk.
Okay.
We'll learn more about assumption of the risk next class, but the idea behind it is that if you engage in something you know is risky, you've been given notice, you're aware of the fact that it's risky, and you get hurt, then that person can defend. You can still get sued. They can still say there's an intentional tort, some of the ones we're talking about. For example, that would be a battery. I can sue and say that, Michael can sue me and say that I engaged in a battery. And assault too, we'll learn in a moment. And I'll defend myself and say, well, yes, I can't argue with that. I kicked the soccer ball and Michael got hurt. Those are the facts. But I can defend myself and say Michael assumed the risk. He knew he could get hurt. He played soccer voluntarily despite knowing that. And who wins? Michael, he's a better attorney. No, I'm just kidding. Who wins? It depends on the judge or jury, right? You just don't know what the outcome would be. So imagine we're playing soccer. I kick the ball. I'm a terrible kicker. I intend to kick it on the ground to my teammate, and instead it hits you square on the face. Ouch. Didn't mean to hit you. Is this an intentional tort?
Yes.
Yes. Why is that?
Because you meant to kick the ball.
I meant to kick the ball. So keep that in mind. I meant to do the act itself. I'm responsible for the consequences of it. Come on, computer. So the first intentional tort we're going to talk about today is defamation. And this is a big one because we see a lot of mean stuff being said on Facebook, on Twitter, in the news. We're going to talk about when it's okay and when it's not okay. So you'll see here, defamation is irresponsible speech that harms somebody else's reputation. Raise your hand if you heard mean rumors that were bad for someone's reputation in high school. You should all be raising your hand. People say mean stuff, right? They're like, hey, this person's really mean, they're smelly, right? We're going to talk about when that's okay and when it's not okay, this idea of the gossip stuff. When we talk about defamation, when it's in writing, it's called libel. When it's spoken, it's called slander. Okay, there's two different types of defamation, and it matters because if it's in writing, we're going to assume it's pretty harmful. If something's written down, it can be shared, it can be retweeted, and it's being spread to more people, then it's going to be more harmful. So we'll talk about what's required under each of these. So under each tort, each wrong, when we talk about criminal law, there's this thing called an element. Remember, you have the responsibility to prove you're wronged. Right? The government has the responsibility to prove in a crime that you did something wrong beyond a reasonable doubt. Here, I need to prove all the elements, all parts of this to be able to say that I was defamed. So there are 4 facts to prove in order to win a defamation suit. The first one, you can write in your notes, number 1. There's our everyday noise. Number 1, the defamatory statement has to actually be made. That's pretty easy, right? I have to make a statement. I have to prove a statement was made. Okay? The big one that's going to be very important when we talk about defamation is the second, which is that it needs to be a false statement. If I say Hannah's smelly and I'm smelly, if It's not a false statement. It's okay to share information under what law?
Freedom of speech.
Freedom of speech. Good job, CJ. The First Amendment of our Constitution says we have freedom of speech. We can share information, but it needs to be accurate. Even if it hurts someone's reputation, even if it's bad, everyone thinks Hannah's smelly. You know, if I'm smelly, it's the fact, then it's not defamation. So that needs to be a false statement. It needs to be communicated to someone other than you. Now, if CJ comes up and says, Professor Weiser, you stink, does that hurt my reputation? It hurts my pride. I'm not feeling great about it, but if no one else heard it, it's not hurting my reputation. When we're talking about being wrong, there needs to be some kind of harm. The last one here, in slander cases, does that mean it's in writing or verbal? Verbal. In slander cases, if someone says something, you have to show an injury resulted from the defamation. There has to be some type of harm. How come I don't have to do that if it's in writing, if it's libel? Yeah, it's written down. We're going to assume it's harmful. So if you don't have this extra element, when it's in writing, you don't have the burden of proving it's harmful. The fact that it's in writing is enough. We're going to assume that that's harmful to someone. So you'll notice lawyers try not to write mean things down. I was just talking to my boss about this morning about how there's a lawyer I know, and he sent something kind of mean about a colleague, and I was going, it's so weird he wrote that down. Because we're all very nervous about what's in writing. Because then it's a record someone can share. If I just say something to you, it's your word versus mine, people forget, right? But writing things down is certainly a problem. Now, is name-calling defamatory? I call my husband a dork all the time. I'm a dork, I know that. You're a giant dork. No, why is that not defamation? Let's work through the elements. So the first element says what?
Was there a statement actually?
Was a statement made? I say my husband's a big dork in front of all of you. Did I make a statement?
Yes.
Okay, so we met the first element. Number two, is it false?
We don't know.
I mean, we don't know.
Probably it's true. The statement was communicated to someone other than my husband. Who did I tell that he was a big dork?
The whole class.
The whole class. That's enough people, okay? Someone other than my husband heard it. And then I said it. It's a slander, right? I didn't write it down. I just said it to you. So is it harmful?
No.
That's where this gossip, calling people names, usually does not meet defamation. We can run into issues as to whether or not it's false or true. Then also, was it really harmful that I called him a dork? Probably not. He'll survive. Okay, go ahead.
So, but if it's spoken, but it's also recorded and like distributed on the news outlet, does it still have to follow under the last clause in the slander cases? Please will show some injury.
Good. So here, Dustin's asking, what if it's also recorded? It's also on YouTube or in the news. Well, then we can assume there's been some harm because now there's a record of it, right?
So it's basically just. So it's not so much as that it's spoken. It's like if there's an actual record of it, like a video.
The idea is whether or not it's caused harm, and if there is a record of it, we're going to assume harm. Does that help?
Yeah.
So if there's a video of you doing something, I mean, that's rough, right? That haunts you forever. It could be retweeted. It stays on the web forever. We've talked about that before. So there's that fourth element. The idea is if there's some type of record, I don't have to prove it was harmful. If my husband, I called him a dork, probably that's not going to harm him. But if it kept him up at night every night, and it really, it was like, oh my gosh, and he ends up losing his job over it, and all this stuff happens. Well, now I can say it's harmful. Usually, just calling someone a name isn't going to make that much of an impact. But if it did, he could say there was harm. He could get a psychologist to write out something saying I was harmed, I couldn't sleep at night, it was emotionally stressful, and he could get some money.
You should stop abusing your husband.
I know. It could be verbal abuse. So, that was just name calling. If it continues, it could be verbal abuse. It could get to the point where it's causing harm if it's being told so often. So slander per se. This says in certain cases, you don't need to prove those elements. Okay, so you'll see here some statements are just so harsh, so potentially damaging to somebody's reputation that we're going to assume they're damaged. You don't have to prove any injury or harm. So remember, if it's in writing, do we have to prove we've been harmed? But even if it's not in writing, if it has to do with an accusation of a serious crime, if you're accusing me of murdering someone, we're going to assume that's harmful, even if you just said it. I don't need to prove it's harmful. That burden's not on me. We're just going to assume it's harmful. Same with here. Claims of having a sexually transmitted disease or being unchaste, meaning that you're promiscuous or having lots of sexual encounters for women. Now again, remember the law's not always fair. This is a little gender bias in the law. If a woman is, called promiscuous, or sometimes you guys like to use the word slut, is that the right? I don't know. If a woman's called this, we're going to assume that it's harmful to them. If a man, someone goes around saying, oh, this guy, he sleeps around, he sleeps with a million different women and men, whatever it might be, then we're not going to assume harm, he has to prove it. Sorry guys, I know that sucks for you, it's just the way the law is, so I want to show that to you. Women have it bad too in some cases. So alleged professional incompetence is also assumed to be harmful. If you're walking around saying that person is terrible at their job, it can hurt their ability to get employment. So if you post something nasty on Rate My Professor about one of your professors, could that harm their chances of getting employment?
Not at this school.
But that's anonymous though.
Dustin makes a fair point. I've been on hiring committees. We're not supposed to look at that kind of information because it biases your decision making. But people on jobs, they Google people. And if they Google people and they see stuff popping up like that, it could hurt your chances of employment. We're gonna assume it's harmful. So if someone says, oh, Professor Weiser, they start shouting outside, Professor Weiser's drunk and she was calling people sluts in class and she doesn't know anything about the law and she's the worst professor I ever had. Do you think that's going to hurt my ability to have employment? Dustin's going to laugh and say, not at this school, but will it hurt my ability to get students in my class? Probably. And so that's where we're just going to assume it's harmful. Okay? It's going to be harmful. So serious crime accusations, calling a woman promiscuous, saying she sleeps around, or having sexually transmitted disease, and professional incompetence, we're just going to assume harm. You don't have to prove it then. Go ahead.
How do they deal with it when like a poster is anonymous? Like, who would they go after
That's
for
tough.
defamation?
That's tough. So for defamation, if someone posts something on the wall that says like all those things about me that I was just saying, Professor Weiser, drinks all this stuff, and they crop I said Weiser like a Budweiser, and they crop a beer. I don't know. Please don't get any ideas. And they post it out there, and we don't know who it was. They're going to try to figure out who it was. If we don't have a person, there's not a lot we can do. We can't bring, mystery person to court. So it's a tough situation. And that happens. There was graffiti a long time, not that long ago, within the past 5 years at the campus center. And it's just like, we can't figure out who it is, then there's not a lot the school can do other than paint over it. The law's not always fair. So some of the defenses. What is consent? Did you agree? Did I say, hey, go ahead, shout whatever you want about me out in the, campus center, it's fine. If you agree to it, you can't then argue and say, hey, this person, is defaming me because you said it was all right. Another one is it the truth? Remember, it has to be a false statement. If I'm sitting here in class with a can of beer, that's true. You're just sharing information. You're protected, like CJ said, under the First Amendment. We're not going to get into this, but there's also some privileges. If you're married, spouses aren't supposed to say certain things about each other, or sometimes there's privilege in certain judicial contexts where you'd be protected, you wouldn't have to say that information. This is the big one students struggle with that I want to make sure is clear. I know this is an old magazine. Here's what I love about the Kardashians. I don't have to update this picture, and there's probably a similar magazine out right now with the same kind of thing on it. It's amazing. I love the Kardashians. So that's Chloe, right? Okay, Chloe.
Yeah.
So what about celebrity gossip? People say mean things about our president all the time, right? They say mean things about celebrities all the time.
Ted Cruz is the Zodiac Killer.
Yeah, there's all this nasty stuff, and it circulates on Facebook and Twitter, and
But isn't that the risk they take for being a celebrity?
exactly, Sean. That's the risk they take if you're a public figure. So if you're a public figure, we have this one extra element you have to prove. If someone's saying nasty stuff about you, it's in writing. They can make these statements, right? And it's being communicated to lots of people. Seems defamatory. If you look at this for public officials, so those are people like police, politicians. I could try to make an argument I'm a public figure as a professor, maybe. I don't know if it would work. But singers, actors, celebrities, they have a harder time winning in these defamation cases because they have to prove what's called actual malice. What that means is that the person knew it was false. They posted it in this magazine that Chloe was caught cheating with another man, knowing this was not true. This wasn't actually Chloe, it's somebody else, right? They knew it was a lie and they posted it anyway to sell magazines. Or if they have what's called a reckless disregard for the truth. If they get a tip in a magazine, Chloe's cheating on her husband, and they just immediately post that without checking the facts, they could be responsible for defamation. What should they do? They get an anonymous tip, Chloe's cheating on her husband, what are they supposed to do?
Find out if it's true.
Find out if it's true, call Kim up, hey Kim, is it true? Is she cheating again? And then she says, yeah, it's definitely true. Loyalty, Kim. And so then we can see, you could be responsible for defamation. Now, it is possible that there are lies out there about these public figures in these newspapers. Does that mean they're going to sue every time? No. Sometimes it's just not, frankly, it's not worth it to them to have to sue. It depends on how far this goes. So sometimes celebrities will sue. The Kardashians actually have sued for these reasons. And sometimes they will. It's a hard case to win. They have to prove they lied or they just kind of didn't check the facts at all when they should have. And they could win. But then they have to go to court. Remember, the court cases are public, so people are seeing this, and it's further publicizing that information that they don't really want people knowing about. So let's talk about defamation for you guys here. We have an activity around it. Do I have any Simpsons fans? Are those still cool? Are they still cool? All right, I got like 2 people. So in your groups, I'm going to have you look at defamation. You'll see a case here. We have Bart and Lisa. Bart is friends with Lisa. And over the course of their lives, Bart and Lisa have shared many secrets with one another. You don't mind passing that around. One day, Bart and Lisa get in a big argument, and Bart lashes out. He begins to post on social media, Facebook, Twitter, and even creates a website entitled LisaIsTheWorst.com. On these websites, he posts stories of the many men she's had sexual encounters with, and even notes that she's not a good teacher, saying that she often ignores her students in class and grades work randomly without a true review of the students' work. Lisa's very upset about this information Bart's posted on the internet. She decides she's been wrong. I want you to think about the elements we just saw. I'm going to go back to defamation, put the elements back on the board. I want you to think about how we can make a claim for Lisa against Bart for defamation with your groups, and we'll talk together as a class. And again, I'll pull those notes up. You want to have them in your notes, but what are the elements required? We need to prove each of these elements for Lisa. I'm going to give you about 5 minutes with your groups. I'll be coming around.
So going back to what they said about like